Mm, oh, yeah. We started with fire, melon, and broke. In the dark, two hearts carrying legacies, carrying scars. But baby, we learned the first ingredients: trust. No secrets, no games, just us and God. We trust in each other.
What up, though? What up, though? What up, though? It's your girl, Raw G, the butterfly. Hey, and welcome to Mind Chaos Brew True Crime. So I got some things to say. Welcome to everyone in the chat. Please hit the like button, share it out, subscribe. The link is pinned. Everybody is welcome to join the show today. I'll drop the link again after I give my commentary. So I'm coming at you today raw. No filter, no sugarcoat. Today we're talking about something that's been weighing heavy on my spirit. Black fatigue. The defense rests and the great black hype has finally failed. And it's not the kind of fatigue where you're tired from working 2 jobs and raising kids. Nah, I'm talking about that deep soul draining exhaustion that comes from watching our own people continuously shoot themselves in the foot. Running on hype, emotion, and premature judgment instead of wisdom, facts, and strategy. And right now, with this latest situation blowing up, where folks are out here declaring somebody guilty or innocent before the testimony even dropped, before any video ever surfaced, before the defense even rested. It's the perfect example of the problem. Let me say this loud and clear from the jump. People of color are doing themselves a massive disservice by not taking even 5 minutes to fully understand the laws and the systems that govern us before jumping to conclusions. That's not respectability politics. That's survival. That's strategy. That's warfare with wisdom. See, if you believe in white supremacy or whatever y'all are calling the system these days, it doesn't need to lift a finger when Black people do all the work for them. Intra-racism, colorism, crab in the barrel mentality, and this rush to judgment culture just because someone is the same color as you inside of our own communities is handing them the victory on a silver platter. You can't unseat power if you don't even understand the tools that they use against you, period. So let's break this all the way down. We started with Black fatigue in and of itself. Because I'm tired, family. I'm tired of the cycle. Every single time something pops off in the news or on social media, especially when it involves one of our own, the same script plays out. Emotions fly first, hashtags trend second, facts. Oh, facts? What's that? Facts come in dead last, if they come in at all. Black fatigue is real. It's watching our community pour all this energy into defending or attacking based on skin color, narrative, political affiliation, or who has the loudest megaphone on TikTok, YouTube, and Facebook instead of the truth. It's seeing Black folks tear each other apart over assumptions while real systemic issues, education gaps, fatherlessness, economic literacy keep destroying generations. Y'all are out here doing the enemy's job. And I'm not just talking about outsiders. I am talking about intra-racism. The quiet poison that we don't like to name. Light skin versus dark skin. You talk white. You not Black enough. Successful Black folks getting dragged for acting uppity or leaving the hood behind. This crab mentality. It ain't keeping us safe. It's keeping us small. It's furthering the very agenda Black people claim to fight against. Because while Black people are busy policing each other's tone, skin tone, and opinions, the real tools of power, laws, courts, contracts, economics, policy, keep operating, whether you understand them or not. Now I want to talk about the disservice of not understanding the law. Let me speak to you plainly. The law does not care about your feelings. The courtroom doesn't run on vibes. Judges don't hand out justice based on how many likes your tweet got. So when you jump to conclusions before testimony is heard, before evidence is presented, before the defense rests, you're not being loyal to the culture. You're being reckless with your own future. Because one day, it might be your son, your brother, your husband, or you in that position. And all the premature outrage you helped build, it poisons the jury pool. It pressures witnesses. It turns public opinion into a weapon that can bury somebody who might actually be innocent, or protect somebody who is absolutely guilty. This ain't new. History shows us over and over, emotional mobs don't build nations. Disciplined, informed people do. You want to fight white supremacy? Learn the Constitution. Study criminal procedure. Know the difference between probable cause, reasonable doubt, and actual evidence. Understand due process. Learn how appeals work. Know your rights when police roll up. Because the people who built the systems that some of y'all call white supremacy understand these tools perfectly. They're precision with this shit. They use them every single day. While y'all are out here arguing over narratives and lived experience. That's the disservice. Y'all are playing checkers with your lives, while they are playing chess with policy, legislation, and precedents. And this latest case, classic example, no video released, no full testimony. The defense just rested, and half the timeline already got the man crucified or canonized based on what exactly? Skin color and assumptions. Because most people cannot tell you any of the elements of what happened in court over this short week. Most people will sit there and complain, well, I don't really know what's going on, but I just don't feel like it's right. I just don't feel like that applies. I just don't feel. I don't feel. That's not justice. That's emotionalism. And emotionalism has never freed anybody. But y'all know it's intra-racism that's fueling the agenda, right? Now, you know our own intra-racism is helping the supposed enemy, right? When a successful Black man gets accused of something, some of us secretly celebrate because, oh, he thought he was better than me. When a dark-skinned brother catches a case, others say, well, that's just how they are. We got Black folks calling other Black folks coons, sellouts, or thugs based on nothing but disagreement or class. That energy That energy, it's exactly what keeps us divided and conquerable. But these be the same ones talking about some how they are pillars of the community. They FBA, Black Pride, Black Power. Tell them about the gun line boys. You teach them because I'm too scary to do so, but I'm going to disrespect you when you don't do what I want you to do. White supremacy, if we're calling it that, doesn't need to create division when we maintain it ourselves. It doesn't need to suppress Black excellence when Black people drag their own for achieving it. What's the real power move? Lift each other when somebody does right. Hold each other accountable when somebody does wrong, regardless of skin tone. And above all, seek truth first. The Bible I stand on says, my people perish for lack of knowledge. Not lack of hype, not lack of outrage, lack of knowledge. I had a whole conversation today. Well, I was trying to have a whole conversation today where people were using their emotions to sit there and try to dissemble and dismantle what the penal code and the statutes of the law is. I was gobsmacked. Y'all have to get a knowledge of the law, knowledge of economics, knowledge of how systems actually work. But let's talk about premature judgment and the real path forward. This premature judgment of innocence or guilt before facts are in, that's the symptom of a deeper sickness in the community. Most people have been trained by social media to react in seconds. But real justice takes time. Real strategy takes patience. Real freedom takes discipline. If we are serious about dismantling whatever force has been holding us back, we have to master the tools. Read the actual court documents. Understand presumptions of innocence. Stop letting algorithms and influencers think for you. Teach our children critical thinking and not just critical race theory. Build wealth. Build businesses. Build stable families. That is how you shift power. You can't beat a system you refuse to understand. Let me say that again for the slow people in the back. You can't beat a system that you refuse to understand. I'm not saying to ignore racism where it exists. I'm saying don't let it become the excuse for your own self-sabotage. Black fatigue is real, but so is Black excellence. And when we operate in wisdom, we are simply unstoppable. So I'm calling on every one of y'all watching. Take a breath before you repost that hot take. Read the law. Study the evidence. Check your own biases, including the ones you hold against each other. Stop feeding the division. Start demanding better from your community. The great Black hype only fails when we keep choosing emotion over evidence, hype over homework, and outrage over understanding. Black people are better than this. Or did you think that God gave you resilience, creativity, and strength to waste it tearing each other down? Let's rise above the fatigue. Let's get informed. Let's get strategic. If you got value from this opening, put it in the comments. But we ain't done. We got work to do. Because there's a whole bunch of people that are going to crash out right now. So I'm going to take you from the beginning to present day. We're going to talk about it the grown and educated way.
True stories that will challenge everything you thought you knew.
And we're back. So let's start with the arrest report, shall we? Now, for those of you that know, if you know, you know. And let me say hello to some people before we get into the topic. Welcome, Cellulite Podcast. Hey, love. Hey, Almanaz. Hey, sis. Hey, Gigi. Hey, Tiggs. That nigga Tiggs. Hey, Lady Renee. How you doing, boo? Hey, Omni. All right. Now, let's get into it. Like the video. Share it out. Do what you want. No, I don't want to do this screen share version. I don't want to do it like this. I think I'm going to do it like this. Okay. So, this is the actual arrest report from April 2nd, 2025. As you can see, on the arrest report, they listed Carmelo Anthony's weight as 130 pounds, even though his athletic profile says he's 162. And it says that he was born in Baton Rouge, Louisiana. 17-year-olds and all that jazz. Occupation of cashier. Cool. From the door, his charge has been first-degree felony murder. So this is not an elevated or hyped up charge. From the initial incident, they knew what they wanted to prosecute him on. Now, Officer Cortez Eduardo says an adult male was taken into custody following a stabbing called on FISD property. Now, let's read the initial narrative, shall we? On April 2nd, 2025, at 10:01 hours, I, Stanley School Resource Officer E. Cortez, Staley School Resource Officer, had heard over the radio dispatch call out a stabbing call at David Kuykendall Stadium. FPD call notes indicate that an athlete was stabbed. The suspect was reported as being a black male wearing a gray hoodie and blue sweatpants. I immediately left my office and ran across the Staley Middle School parking lot towards the southwest entrance into the stadium. So for those that keep saying this wasn't school property, they called the school resource officer and the Staley Middle School to come to the field that is attached and named after a beloved coach that had passed away on school property. As I entered the stadium, 2 high school age students informed me that the victim was on the north end of the stadium by the bleachers under a Memorial High School tent. I did not identify these students. Next, I proceeded towards the north end of the stadium, visitor side on foot. As I got closer to the north end, I could see the Memorial High School tent with multiple individuals under the tent. Once I arrived onto the north side bleachers, an adult male who was on the track pointed out the suspect. I was not able to identify that witness. The individual that was pointed out to me was a black male wearing a gray hooded sweater and dark colored Nike pants. The suspect at this point was on the track on the north end. There was a chain link fence that separated me from the suspect. I gave the suspect instructions to keep his hands up in the air. During this time, the suspect said verbally out loud, "I was protecting myself." It should be noticed that I had not questioned him about the incident when he made that comment. I asked him if he had any weapons and he said no. I patted him down for weapons while we were walking along the fence, and I did not locate any on his person. So this is immediately after Austin Metcalf was stabbed. No weapons, because he allegedly threw the weapon into the bleachers. I instructed the male to continue to walk along the fence, which he complied, towards an area where there was an opening in the fence that led off the track. While walking him off the track, the suspect also said he put his hands on me. I then detained the suspect in handcuffs, hands cuffed behind his back, and had him sit down on the ground. Officer A. Ritchie had arrived on scene at that time. I conducted another pat down of his person, then searched his person after he gave me consent. No weapons were located. While the suspect sat on the ground, I advised I had the alleged suspect. The suspect then responds and says, "I'm not alleged, I did it." Now, this is a quintessential linchpin. He admits right there that he did it. And yes, he did say, I told him not to touch me and I was protecting myself. He did also say those things, but he also admitted that he did it. Now, when we initially covered this case, we cited that this is a moment where he should have been quiet. You have the right to remain silent. That's what you need to teach your children, to shut up. Next, Officer Ritchie and I walked the suspect to patrol vehicle 2412, which was on the northeast gate of the stadium. As we were walking to the squad car, the suspect was emotional and said, he put his hands on me. I told him not to. I did not question the suspect about the incident while he was escorted to the patrol video. I searched his person once again and had him sit in the backseat area. While the suspect was in the backseat, I noticed fresh blood on his middle finger. I verbally acknowledged that I saw the blood out loud so that it would be captured on my body-worn camera. So he had a fresh wound on his middle finger. That's the only injury that he had at the time of the arrest. It should also be noted that the suspect asked me if he was going to be okay while he was in the back seat. I then identified the suspect. He provided his name and date of birth, and I ran it through FPD dispatch. Then he was taken to the jail. And if you guys go through and look, I may put the link in. All of these officers are saying the same thing. He had on a gray hooded sweatshirt, sweatpants. The only injury was to the middle finger. And for those of y'all that are geeking about this trial, you should be. There should have been way more testimony, because these are the people that were there at the scene of the crime, identified by police officers. And of course, you don't see their full names because they've been blacked out to protect their identity. But there's a whole laundry list of people. But only 5 were called. That's kind of weird. But people will tell you that they are here to protect the children. And don't take my word for it. These are photos from his arrest. He was jumped, right? According to what these emotional Black people will tell you on social media. Where are the wounds? I don't know if you've ever been jumped, ladies and gentlemen. But if you've ever been jumped, it's a rarity that you walk out of being jumped looking like this. Where's the injuries? Because he didn't fight. He stabbed. He was in fear for his life. Where is the deadly bodily force? Where is it? Maybe I can't see. Maybe I'm missing it. Maybe it just didn't happen. Now, when we look at the charges, let's look at the Texas Penal Code. Criminal homicide. He was in fear of embarrassment. Stop it. I'm trying to stay focused. I'll be with y'all in a minute. I ain't playing with y'all. So, a person commits criminal homicide if he intentionally, knowingly, recklessly, or with criminal negligence causes the death of an individual. Now, these people keep saying this young man is not guilty because of self-defense, but I want you to read over, and they think it includes premeditation. And in the state of Texas, it in fact does not. Let's read that again. A person commits criminal homicide if they intentionally, knowingly, recklessly, or with criminal negligence cause the death of an individual. Damn. Now, murder. That's the charge. Section 1902, murder. In this section, adequate cause means cause that would commonly produce a degree of anger, rage, resentment, or terror in a person of ordinary temper, sufficient to render the mind incapable of cool reflection. Sudden passion means passion directly caused by and arising out of provocation by the individual killed or another acting with the person killed, which passion arises at the time of the offense and is not solely the result of a form of provocation. A person commits an offense if the person intentionally or knowingly causes the death of an individual, intends to cause serious bodily injury, and commits an act clearly dangerous to human life that causes the death of an individual, commits or attempts to commit a felony other than manslaughter, and in the course of and in the furtherance of the commission or attempt, or in the immediate flight from the commission or attempt, the person commits or attempts to commit an act clearly dangerous to human life that causes the death of an individual. Well, from what we know about the case, we know that he damn sure falls under number 2. He intended to cause serious bodily injury and commits an act clearly dangerous to human life that causes the death of an individual. Now, whether he had remorse is not necessary. That has nothing to do with the statute. Because what did he say? I was protecting myself. I'm not alleged I did it. This is what he said on body camera footage. But people would then cite self-defense. No, he wasn't. He was not overcharged, Almond. He was charged within the letter of the law. In my opinion. This is not legal advice. Always check in with the lawyer. Now, in Penal Code Chapter 9, deadly force in defense of a person. A person is justified in using deadly force against another if the actor would be justified in using force against the other under Section 913, and when and to the degree the actor reasonably believes the deadly force is immediate and necessary to protect the actor against the other's use or attempted use of unlawful deadly force. And again, I just want to know, does he look like he was the victim of unlawful deadly force? Does he? Do keep in mind, these are the mugshots from the day of the incident. Does he look like he was underneath unlawful deadly force? One injury to the middle finger to prevent the other's imminent commission of aggravated kidnapping, murder, sexual assault, aggravated sexual assault, robbery or aggravated robbery. Were they trying to rob him? Because from both sides of the aisle, it was, they told him to get out from underneath the tent, and he didn't want to go. So even if you wanted to argue Austin grabbing the backpack could be viewed as robbery or aggravated robbery, by his own admission, by the defense's own admission, that's not what happened. They asked him to leave. Were they trying to take his booty? I don't think so. They just wanted him to go. Were they trying to kidnap him? Not by telling him to leave. Was Austin trying to delete him? I don't think so, not with the shove. Now, the person also knew or had reason to believe that the person whom against the deadly force was used unlawfully and with force entered or was attempting to enter unlawfully with force the actor's occupied habitation, which means their house, their vehicle, their place of business, or their employment. Unlawfully and with force removed or was attempting to remove unlawfully and with force the actor from the actor's habitation, vehicle, or place of business or employment. Oh! Was committing or attempting to commit an offense described by subsection A to B. What's that? Oh, you mean to prevent... That's what that's talking about. The kidnapping and all that good stuff. The person also did not provoke the person against whom the force was used. Was not otherwise engaged in criminal activity other than the Class C misdemeanor. A person who has a right to be present at the location where the deadly force is used, who has not provoked the person against whom the deadly force is used, and who is not engaged in criminal activity at the time deadly force is used, is not required to retreat before using deadly force. But the key word is at the time that the deadly force is used. Uh-oh. 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 And you can even do that if someone is preventing someone else from committing suicide or inflicting serious bodily injury to themselves. But you have people that will sit there and talk real crazy. But I don't even want you to take my word for it, because apparently, because I'm black, because I'm a black person, and I'm a black woman, according to black people, I can't read nor can I understand the law. They only respect the law when it comes out of the mouths of white people. So let's listen to a white man tell you.
On at the end of this case. They are all found in Section 9 of the Texas Penal Code. We're going to be talking about Section 9.31. That is just the use of force in general. When can you use any kind of force in defense of yourself or others? The second one is going to be Section 9.32, which is the use of lethal force. And when is that justifiable in Texas? And of course, we do need to talk about lethal force because the force used was plunging a knife into another person's chest. So I don't care what state you're in, that constitutes lethal force. And then the third thing we're going to have to do is take a look at Texas law on provocation. In many other jurisdictions, it's actually called the first aggressor standard. But we're going to have to go over that instruction as well, because that's going to be a big component of this case as well. Okay. In Section 9.31 of the Texas Penal Code, the ability to use any force, and I'm just talking about any force in general, only exists in Texas in the following situations. Except as provided in subsection B, a person is justified in using force against another when and to the degree the actor reasonably believes the force is immediately necessary to protect the actor against the other's use or attempted use of unlawful force. Okay, and I want you to remember that except as provided for in subsection B, because we're going to circle back on that. But in general, and this is not unique to Texas, this is just about every state operates this way, is we only get to use force in defense of ourselves, others, or property, so long as the force we use was 1, necessary, 2, reasonable, both subjectively and objectively, and finally, proportional. And it is this last element here that can be a very difficult hurdle for the Anthony defense team to overcome. Because if in fact the force we use has to be proportional to the force we're trying to repel, then typically we don't get to use lethal force unless we are encountered with imminent threat of lethal force being used against us. Section 9.32 of the Texas Penal Code.
Oh shoot, I guess I can read. Damn. Thanks, Mom.
Code specifically states a person is justified in using deadly force against another, one, if the actor would be justified in using force against the other under section 9.31. So in general, you have to first have the lawful ability to use some type of force, and then you must prove, two, when and to the degree the actor reasonably believes the deadly force is immediately necessary, A, to protect the actor against the other's use or attempted use of unlawful deadly force, or B, to prevent the other's imminent commission of an aggravated kidnapping, murder, sexual assault, aggravated sexual assault, robbery, or aggravated robbery. There are some other justifications, but they require that you are being forcibly removed against your will from your home, your car, your place of business, things such as that. So unless you are encountered with the imminent threat of unlawful deadly force being used against you, or you have one of these very serious felonies right here being committed against you, the right to use lethal force is not available under Texas law. Now, if the allegations are,
damn. So let me get this right. You don't have to have a degree or pass the bar to comprehend. No, you don't. Shout out to all the jailhouse lawyers that actually get themselves free without having passed the bar because they simply can comprehend the letter of the law.
that the victim, Mr. Metcalf, was attempting to use unlawful lethal force against Mr. Anthony, then his response with lethal force would be justified. Whether that evidence is going to come out remains to be seen, but there has been no allegations so far to support any claim of that nature. But you see, there are exceptions to both 9.31 and 9.32, where if these events occur, then the person is absolutely precluded from ever raising self-defense as an affirmative defense of their case. They literally forfeit the right of self-defense. And in both statutes, we find that there is an exception when the person did not provoke the person against whom the force was used. That's right. You cannot be the person who provoked the confrontation. In many states, this is called the first aggressor. In simple terms, you can't pick the fight and then later claim you were acting in self-defense. And in some states, like mine, for example, there's a jury instruction that says that if you provoke the confrontation, no matter how belligerent the response is from the other side, you cannot avail yourself of self-defense. But then in section 9.32, there are other exceptions written into when you can and cannot use deadly force. That is, are there instances in which you would forfeit the legal right to use lethal force? Yes, there is, because the statute specifically reads, a person who has the right to be present at the location where the deadly force is used, who has not provoked the person against whom the deadly force is used, and who is not engaged in criminal activity at the time the deadly force is used, is not required to retreat before using deadly force.
So you have to be present at a location where you're allowed to be and not be a provocateur. Damn. And not be violating any policies or laws. Because if you guys don't know, let me educate you. According to Frisco School District, violating their policy by having a weapon on school grounds can get you a DEAP violation, which in fact is adjudicated by the local police department. And then it gets you placed in another school,
as described by this section. Which means if Mr. Anthony was not permitted to be in that location or was engaged in other types of criminal activity, such as trespassing, such as making harassing threats or anything of that, then he would not be able to avail himself of self-defense, and certainly not able to avail himself of lethal force as used in self-defense. So this is...
And just so you don't have to take my word for it, so I would never expect you to take my word for it. After the conference, if a student is placed in a DAEP, the appropriate administrator shall write a placement order and a copy of the DAEP placement order and information for the parent or person standing in parental relation to the student regarding the process for requesting a full individual and initial evaluation of the student for the purposes of special education services shall be sent to the student and the student's parents no later than the second business day after the conference. The board's designee shall deliver to the juvenile court a copy of the placement and all information required by Section 5204 of the Family Code. Damn. Would that be breaking the law?
This is what might be the uphill battle for the Anthony legal team, depending on how the testimony comes out. Because if a judge believes that he was the one who provoked the confrontation, that he was the first aggressor, then a jury will be given the instruction on provocation, and they will be instructed that if you believe Mr. Anthony provoked the conflict, then they will ignore the self-defense instructions. In some jurisdictions, as a matter of fact, if a jury believes that the person was in fact the first aggressor, they are literally instructed to disregard any self-defense instruction that might be in that instruction packet. But listen, even if the jury believes that Mr. Anthony was not the initial aggressor, that he did not provoke this confrontation, that he could lawfully remain in that location, then yeah, his use of force may be lawfully justified so long as the force that was used was what? That's right, proportional. And under Texas law, we only get to use lethal force if we are either in imminent threat of death or serious bodily injury, or we're having any one of these very serious crimes about to be committed upon our person. Absent a finding of that nature, this is no longer lawful self-defense. Rather, it is a murder. So for everybody out there who's watching this case, I understand everybody out there who's getting all worked up about this case. Let me give you a piece of advice. Everyone take a deep breath, let all the evidence come out, and then we can make our own minds up. But at the end of the day, the only minds that are going to really count in this, well, that's the 12 that are sitting in the box. All right, listen, the case once again is State of Texas versus Carmelo Anthony.
Now let's dig deeper into 5204, shall we? Referral to juvenile court, notice to parents. The following shall accompany a referral of a child or a child's case to the office or official designated by juvenile board to be provided as quickly as possible after referral. All information in the possession of the person or agency making the referral pertaining to the identity of the child and the child's address, name, address of the child's parents, etc., etc. Complete statement of the circumstances of the alleged delinquent conduct or conduct indicating a need for supervision. When applicable, a complete statement of the circumstances of taking the child into custody. Damn. And when the referral is by an officer of a law enforcement agency, a complete statement of all prior contacts with the child by officers of that law enforcement agency. The office or official designated by the juvenile board may refer a case to law enforcement agency for the purposes of conducting an investigation to obtain necessary information. If the office of the prosecuting attorney is designated by the juvenile court to conduct the preliminary investigation under Section 5301, the referring entity shall first transfer the child's case to the juvenile probation department for statistical reporting purposes only, or in the creation of the statistical record or file the case. The probation department shall within 3 business days forward the case to the prosecuting attorney for review under 5301. So again, when people are saying that, oh no, he didn't commit a crime and it's just no big deal, isn't it? I guess according to Frisco's School of Board of Conduct, Code of Conduct, it just very well is.
Carmelo Anthony is charged with murder in the death of Austin Metcalf. Anthony's attorneys claim the stabbing was self-defense. Our Trevor Sahaki is live outside of the courthouse. And Trevor, the prosecution rested its case on Saturday, and the defense is continuing to make its case today.
Yeah, that's right, Karen. The defense is now on its third witness of the day today. That's yet another student who was at the track meet on the day of the stabbing. The pattern of questions from the defense seems to be aimed at showing how Carmelo Anthony was not out of place under another team's tent on the day of the stabbing, and how Austin Metcalf provoked the altercation between the two of them. Now, this comes after the defense briefly questioned a Frisco police officer who confirmed it is legal to carry a knife in Texas. Before that, the first witness of the day was another student who was at the track meet. He described seeing Carmelo Anthony under the Memorial High School tent, and at first, everything seemed normal. Then he saw what he thought might be a fight breakout. Quote, "What did you see when you first noticed something was wrong?" Witness, "I saw the arms go out. I see arms make contact with Carmelo." The witness then described Anthony's emotional state after the stabbing, calling him, quote, "distraught." However, when the prosecution cross-examined the witness, it emphasized that he did not see the actual stabbing. He was on the field at the time. Quote, "You had a story in your head when we visited, correct?" Witness, "Yes. And when you saw the video, your eyes were open to what actually happened. Is that right?" Witness, "Yes." The witness also told the state he would have left another team's tent if he had been asked to if he was in a similar situation. This trial is expected to go through the end of the week. Live in McKinney, Trevor Sahaki, CBS News, Texas.
But we want to sit here and not hold these children accountable to their bad behavior, right? Now, also earlier today, somebody told me that what I was saying wasn't true. So, possession of prohibited items. This, as you can see, is from the live version 2025 to 2026 Frisco ISD Student Code of Conduct. Possession of prohibited items. Students shall not possess or use fireworks of any kind, smoke, stink bombs, or any other pyrotechnic device. A razor, a box cutter, chain, or any other object used in a way that threatens or inflicts bodily injury to another person. A look-alike weapon that is intended to be used as a weapon or could reasonably be perceived as a weapon. An air gun, a BB gun, a short barrel firearm, ammunition, a hand instrument designed to cut or stab another by being thrown. A firearm silencer or suppressor. A location-restricted knife. A club, a firearm, a stun gun, knuckles. A pocket knife or any other small knife. Mace or pepper spray, pornographic material, tobacco, matches or a lighter, a laser pointer. Any articles not generally considered to be weapons, including school supplies, when the principal or designee determines that a danger exists. So when I said a pencil, yeah, that's in there too. For weapons and firearms, see DAEP placement and or expulsion for certain offenses. In many circumstances, possession of these items is punishable by mandatory expulsion under federal or state law. And again, you don't have to take my word for anything. Do your own research. But the way this case is set up, Carmelo Anthony's behavior is insane. It's insane. And it's insane that so many people just jumped out the window to defend this young man, taking into no account, right? This ain't legal advice. It's just facts. It's just facts. Taking no account in or having no compassion for Austin Metcalf's family and his loss of life. But let's listen to what Fox News had to say about the whole situation after the defense rested today. And let's also talk about that before we show you this. So the prosecution put on, they put on a case. I won't say it was a dazzling display because really and truly they didn't have to work that hard if we're being honest. And they did not work that hard because the defense absolutely did not use objections. They did not call into play anything that the prosecution showed to be facts. They didn't really cross-examine the witnesses to the degree that I would have expected them to cross-examine the witnesses, especially when someone's life is in the balance. They did a piss poor job today, in my opinion. and then they rested right after lunch. It was quite a disservice to this young man. If anything, I would say I believe he has a good chance of appeal for ineffective counsel. But let's see what the news has to say. The white people.
Defense has rested their case in the Carmelo Anthony trial as the Texas teenager is accused of fatally stabbing a 17-year-old Austin Metcalf at a high school track meet. Anthony, now 19, charged with a 2025 death in that confrontation. The case has drawn national attention, featuring emotional testimony. It wrapped up today. The jury potentially has their hands on it tomorrow following closing arguments. And the case began moving forward very rapidly as prosecutors say the stabbing was an unjustified attack stemming from an argument over whether Anthony could be under the tent of Metcalf's team. Anthony's attorneys have argued that he acted in self-defense and reacted in fear during a split-second moment after Metcalf made physical contact. Let's be joined right now, friend of the program, criminal defense attorney Matt Timpanik. And Matt, this was slated to go a couple weeks, but now the state resting, the defense resting on Monday. It will be in the hands of the jury starting potentially on Tuesday. What do we make of just the swiftness of this trial so far?
It has moved exceptionally fast for a homicide case. Both sides are asking the correct questions and succinctly, which is very important in a criminal case. That said, as it stands, I definitely think the prosecution's case is a lot stronger. When you heard the evidence, there didn't seem to be any kind of opportunity that the alleged victim, Austin Metcalf, made that would put Carmelo Anthony in serious imminent fear of serious bodily injury or death, which is required for self-defense under Texas law.
Yeah, and obviously they made some of the cases, the defense only calling a handful of witnesses today, and notably no Carmelo Anthony taking the stand to share his first-person perspective on how he felt, how he saw the moment in which it all went down at that high school track meet. Behind that, obviously, he doesn't have to testify. Do you think there was a reason? What did they weigh in that decision?
When you decide whether or not your client, because the decision lies with the client alone, whether to testify in a criminal case, you have to decide what is the upside in doing so. Is your client somebody who's going to be able to sway the juries? Is he going to be able to bring sympathy? Is he going to be able to lay out what he was thinking at the time of the incident? My feeling is that that's not the case, because this is a self-defense case. You have to put the jury in your shoes at the time of the incident. They need to feel what you were feeling, your decision-making process, because the burden stays with the prosecution throughout the case. But as it stands, they really don't, the prosecution witnesses and the defense witnesses didn't really paint a picture of what Carmelo Anthony's decision-making, what it was in those moments before he stabbed Austin Metcalf. So if you're a juror, you're thinking to yourself, how are we supposed to acquit this person? Because I didn't see this kind of imminent fear of seriously bodily injury or death in this based on the facts and evidence presented, and that's required for safe self-defense.
Yeah, obviously very difficult to kind of go through all of these. And we heard so much testimony from it. And we do know closing arguments taking place on Tuesday. Then obviously the jury will have it in their deliberations and they will be sequestered if it goes beyond Tuesday. Why do they do that? Why is the judge putting it in a place where they won't be able to go home? They'll have to kind of stay sequestered until they come up with a decision.
So this is a high-profile case. Normally, cameras are allowed in a courtroom in a state case. So I think what the judge is thinking is, based on the social media traffic on this case and the publicity it's gotten, that it's best to be able to keep the jurors sequestered and just base their verdict and their deliberations based on the evidence presented and ignore the outside noise. That is deafening at this point in this case throughout all major news outlets as well as social media.
Yeah, that's so very true. So many people watching this, awaiting a decision from this jury as well. We do know closing arguments taking place tomorrow. What kind of arguments might they make? What type of points will both sides be trying to get across?
The prosecution is going to get into the fact about how, if he's claiming self-defense, there has to be evidence that shows that Carmelo Anthony was reasonably in fear of serious bodily injury or death. What we heard, I think he touched his shoulder, maybe got shoved, neither of which are a situation where a reasonably prudent person would believe that their life was in serious bodily injury or death. That's what they're going to hammer home. They're going to talk about how he brought the knife to this track meet. That knife was not allowed on campus. The size of it, I believe it was 5 inches. So when you're thinking about the size of it, this is not just a little Swiss Army knife that somebody would carry around with them wherever they go. This is a rather large knife, and you're thinking to yourself, why did this individual bring this to this track meet? The prosecution would be like, the defendant shouldn't have been in this tent at the time of the incident. Put it all together, and he should be convicted. The defense is going to say it's like he was outmanned by numerous people inside this tent. Mr. Metcalf was talking to him in a very aggressive tone. He feared that he was about to be triple teamed by numerous people, so he got the knife out to defend himself with one single knife. But the problem with that is there were words that were said before that he was like, just touch me and you'll see what happens, almost egging the alleged victim on, in this case, to be able to do something so that he could respond. And that's definitely something that's going to be in the forefront of jurors' minds when they go to deliberate.
Yeah, they're trying to paint the picture for both sides, prosecution and defense, come for those closing arguments. Obviously, Carmelo Anthony on trial, facing the charges of first-degree murder, which are very serious charges. Will the jury be able to weigh anything lesser if they potentially don't all agree on that one?
Yes, they'll be able. I believe they'll be given the instruction for second-degree murder and voluntary manslaughter. It could be a situation where the jury might feel that first-degree murder might be a little over the top, and they might compromise on second-degree murder. Obviously, you never know what a jury's going to do. You don't know what facts they are. The composition of the jury is different ethnicities, backgrounds, genders. So it'll be interesting to see what they actually come to when they make their verdict.
What else big takeaways can you take from this trial? It went very fast, very expeditiously. What else do you want to know before I let you go?
What I would want to know is how, when the prosecution is presenting their closing argument, how are you going to convince the jurors that Carmelo Anthony was not acting in self-defense? What actions are you going to hammer home during your closing arguments to convince them to convict of some kind of murder charge?
Yeah, first-degree murder, obviously facing some significant time if convicted. All right, Matt, thank you so much for joining us. I appreciate your time, your insight. You're on Live Now from Vox.
And that's ultimately the coup de grace. How do you convince a jury that is a reasonable expectation that someone shoving you will result in a loss of life? How do you convince a jury that, hey, nah, don't worry about it? He definitely wasn't in fear of his life. Now, what my opinion is, and this is the knife, by the way. This is a knife that took somebody's life. So stop thinking that little knives can't do nothing. Little knives most assuredly can do something. They can do some nasty work. Nasty work. I think that the jury's going to find him guilty. If they acquit him, cool, they acquit him. But I honestly believe that they're going to find him guilty. And I pray that black people don't do the black people thing and loot and try to act a damn donkey based on whatever the decision is. And if they acquit him, I pray white people don't get to acting an ass as well. Dropping the link as I give my little final thoughts. If y'all want to come up and talk about it, you're more than welcome to. If you don't want to, that's cool as well. But at the end of the day, like, this case has been a shit show. It's been ineffective counsel at best. And it's not even whether or not they had a lot of ability to adjudicate adequately. They still could have did a little bit of anything. Tried anything. Hello, honey. Welcome to the show.
Hey, baby, what's going on?
Nothing. I just had to come and put some things into perspective so people can have an accurate timeline as we count down to the verdict of Carmelo Anthony.
Thanks. And you know what? I'm glad you actually took the time to get the educational material to remove all of the emotion from it. I think that's the biggest problem in all of this. Too many people are too tied emotionally to the possible outcome of this case. But even more so, apparently, it's a lot of people with a lot of trauma. I was thinking about this while you was up here talking and really just like showing all of the details. A lot of people really are showing a lot of emotion behind what it is that they feel would happen to them. Am I missing that?
No, I would say that's an accurate statement.
And because of the fact that they want to self-relate to who Carmelo looks like, which can be a mirror reflection of them, a lot of them just really is just like, oh well, I just don't understand. Well, it's a lot of things that can be easily understood if you just use basic comprehension. It's not that hard to really dig through. But I don't know. I just think that, like, after everything that has happened so far since the beginning of this entire case, you find that a lot more black people are more fearful than what we thought of. Apparently, a shove is deadly. That's lethal force.
Right. I mean, the last time I checked, there's nothing wrong with getting your ass whooped. Just losing a fight the good old fashioned way, and then potentially getting your ass whooped, and then you fight another day.
One would think that, but what have we been hearing for these past year and a half, couple of months, weeks? Apparently, it's the most deadliest. That a white person's push is so deadly that it can take you out of your body. It can remove your whole entire family lineage. It's a generational push. I'm just saying, like, the way that people are describing this push from Austin Metcalf, it sounds like black people's kryptonite.
Yeah.
I ain't trying to be funny. And that a person's push constitutes lethal force. It's ridiculousness.
I just think, really and truly, a lot of people just want to be right. They're concerned with, oh, I've mopped the floor with you for this argument. That's great. Hell, even if someone feels that they've won an argument in these social media spaces and in the news, right?
Mm-hmm.
You're not the jury. And I think that one lawyer said it best. The only people that really matter in their judgment of this case is the 12 and the alternates that are sitting in the courthouse.
Yeah.
That are privy to video footage that we still to this day do not have access to.
Yeah.
See, everything else is really conjecture. It's presumptions. But they have the cold, hard facts. And I'm really quite disenchanted with the defense team and how they handled the case. There was not one objection. There was not one, Your Honor. Like, if anything, I feel like that's what the community should be most aggravated about. The lack of effective counsel.
Facts. That's a fact.
So now let me ask you a question. If you if he does wind up getting charged and found guilty, will you be shocked?
No, I wouldn't be shocked. I wouldn't be shocked if he was found guilty of this charge. I wouldn't be shocked if they found him guilty for a lesser charge. I wouldn't be shocked if they acquitted him. I wouldn't be shocked if they said that he proved his case of self-defense. One thing about this imperfect, perfect system that we have is that it's bound to go either way. It's not up to us. We're just the spectators in this whole entire ordeal. So it doesn't surprise me. What will surprise me will be the community reaction. I'm not just talking about the Black community, I'm just talking about everyone. The nationwide reaction to this whole entire thing. That's going to be the surprising part. Which politician is going to try to remove the meat from the bone on this one? Which content creator is going to say "I told you so"? Which content creator going to say or going to be crying, saying this is an outrage and this is a catastrophe. This is terrible for Black people? Or are people going to come out and say this is a win for Black people? So a win for Black people is the body of a young white man. Okay. A defeat for Black people is a Black man going to jail? Or can we just be honest and just say that the actions and behaviors of one young man changed the paradigm for not just himself, but someone else, where their life came to an end and the decisions that he made? But it's okay, because accountability is something that can be sidestepped at the drop of a dime. But no problem. You know, what will be shocking to me is if he's found guilty, if everyone just remains home and we just go back to normal. Or there's the other side of the coin. Everyone will go out in the streets and start behaving like the predicated behaviors and people that we've always been described as. They describe us as savages and animals. So you're going to go out and prove them right? Okay. That would be crazy. Give them the reason to, what do they always say? We're oppressed people. Give them the reason. Got it.
Well, this is one thing that I've said for a long time, that they've been looking for a race war to enact martial law since
Absolutely.
Trayvon Martin. Is this going to be the case that enacts martial law? And that's something that I need people to bear in mind.
Mm-hmm.
Y'all say your president is a racist. You say your president doesn't care about Black people. So if y'all go out there in the street and start acting a donkey under what you deem a racist president in a climate where nobody gives a damn about y'all, that's what Michael Jackson said, right? All I want to know is that they don't really care about us. So if you go ahead and you do all of that in this type of political climate, what then?
Yep.
And you know what else really has irritated me with all of these conversations?
What's that?
That a lot of these people have not actually taken into account what a guilty or not guilty verdict means for our children, especially a non-guilty verdict. How many little Black boys will die if the verdict is not guilty?
Preach. Preach.
See, this is why people gotta really start thinking shit like 10 and 20 steps out of the box. Because if the law is passed, this now is case law. This becomes case law. That it's okay if you're a little bit afraid, if somebody just shoves you, it's okay to take their life. Is that the precedent that you want to set? And I think that's going to be one of the things that are very heavily on the minds of the jurors as they go into deliberations. Do I want to set case law that is going to make it okay for other people's children to be deleted?
I can tell you this much. I hope people learn lessons from whatever verdict is going to come from this trial. I hope that people really, instead of what's the word I'm looking for? instead of people driving into their emotions, I hope that people look into the facts of this case and use it as a lesson and a teaching point for future references.
Facts.
But also at the same time, I have little hope for humanity. But that's me. I don't think people can look at things through the lens of truth instead of
Of normalcy.
And truth and normalcy and balance. I think that people just they need reasons to be enraged, and unfortunately, this might push people over the edge, and y'all might get that race war that y'all want. A lot of y'all not prepared for it. Hate to say it, but it's just the truth.
Exactly. Well, hon, go ahead and give your final thoughts. Like I said, I didn't have any intentions of staying up here a long time. I just came up here to just get that off my chest without, being interrupted by people that don't have good comprehension skills of the law.
Absolutely. My final words will be a reflection of what it is that I just said. I hope that people take the time to really look into the details, and once everything starts coming out, hopefully, because I did have an idea that I don't think anything is going to be publicly released from this case, because there is the age factor we have to take into account. I don't think there's going to be any public video, but I hope people can really look at everything that this case has entailed and really just draw a lesson from it. And whatever lesson that may be, I hope it's a positive one. But love your kids, teach your kids, and be aware of your surroundings. That's all I got. Thank you for having me up.
Thank you for coming. Take care. So yeah, ultimately, this is not a win for either side of this. And there are some rough days ahead, either way it goes. But Black people, if you really care about your community, start actually knowing the laws that bind you. As usual, the ones who needed to be here aren't. Of course they're not. And that's okay. That's because they didn't need to be here. Actually care about your community by learning the laws, learning the policies, learning the procedures, and just simply doing better. Take care.
Bro, G. Stand tall, can't break me. No, don't fuck with me. Don't fuck with me. Bad black queen, whole world gon' see. Yeah, don't fuck with me. Don't fuck with me. Diamonds on my wrist, mine sharper than a key. Don't fuck with me. Don't fuck with me. Step in the room, all eyes on she. Don't fuck with me. Don't fuck with me.
Look, I'm the headline, you a footnote, baby. I write the rules, you just quote them, maybe. They throw dirt, but I bloom like daisies. Pressure make a queen, can't faze me. Walk in, shut it down. Bossy with a grin, I ain't waiting on respect. That respect built in. When they see me, they salute, cause the crown legit. And if you try to block the shine, you dismiss, bitch.
Raw G, stand tall, can't break me. Don't fuck with me, don't fuck with me. Bad black queen, whole world gon' see. Don't fuck with me, don't fuck with me.
Yeah, I'm a storm in Chanel, hurricane and some hills. Turn struggle into billions, manifest what's real. You pressing for a crown, sit back, chill. I was born in the throne and I've been no will. They whisper my name cause they know it here. Heavy talk slick on the net, but in person not ready. I'm the fire and the flood, can't box me in steady. Raw G, no cage, yeah my aim too deadly.
Raw G, don't play with me. Don't play. Queens run the board, checkmate, you see. Talk loud, but your moves too weak, too cheap. I'm the nightmare you fear when you go to sleep. Raw G, stand tall, can't break me. Don't fuck with me, don't fuck with me. Bad black queen, whole world gon' see. Don't fuck but